had my way, I'd have every decision made by a jury rather than by a judge. And I'll tell you why. I know that's impractical, by the way. A judge has got to guide the case, be the referee, and so he's going to make a bunch of decisions. But any important decision, if I have a choice, I'll go to a jury rather than judge. I don't care if I'm plaintiff side or defense side. Why? Because a judge, unless he or she is very new to the bench, has been around the horn, seen it all, and formed a lot of views from listening to other lawyers on other cases. Lawyers I can't control. Lawyers I wasn't there to be able to show him or her why that was the wrong point of view. The jury is completely new to the legal system. Maybe some of them have sat on another case or two, but not so that they become steeped in it. Not so that, they don't hear the cries of widows and orphans anymore. Juries hear the ultimate justice in the case. Juries don't get as hung up with the details of the case all lining up, as they never do in life. They never line up. Juries have a lot of tolerance for ambiguities that many judges don't have. Juries bring you 12 people together with different backgrounds. I can't control any one, but by putting them all together, 12 or 6 in federal court, but by putting them all together, I get a better mix, a better representation of the community than I get with a single judge, who's going to be an outlier in some respect or another. So in general, I want to be in front of a jury. And when you're in front of a jury, people say, well, save that for opening statement or closing argument, or we'll come to that, so forth. You're giving your closing argument from the time that you set foot in the courtroom. The first time the jury sees you, they're starting to form an opinion. Does this lawyer have a command of the facts? Is this lawyer telling me the truth, or is he trying to blow smoke at me? Is this lawyer credible? Can he give me a good reason for seeing the world the way he sees it, or the case the way he sees it? The jury is constantly evaluating that, from your opening statement to your cross-examinations, to your witnesses, to your arguments. You can't compartmentalize these things and say, well, over here, this went terribly for us, but that's all right, we'll make it up over here. I'm not saying you give up when you have a setback, but I'm saying the jury sees all of that and brings it together, and they don't do it with mathematical precision. They do it with a sense of what's the ultimate right result here. So when I'm arguing to a jury, if you're standing in the back of the courtroom, you could fire a gun and I wouldn't hear it. What I'm focused on is that jury, it's the world exists with me and them, and I want to reach out figuratively and bring them here close to me in front of the fireplace. And I'm going to hold back that objecting attorney over there and try to brush him back, and I'm going to keep that judge calm on the bench and sitting there as a referee as he's supposed to be and not playing in the game, him or her, get them up there, other lawyer over there, just bring that jury in and talk to them about my situation, about our case, our client, our problem. Here's what you need to do, and here's why. So with a jury, it's a lot more about personality. It's a lot more about liking people and being comfortable with people. It's a lot less about touching all of the technical points. If you think about a summary judgment, for example, say causation. Lawyers go in and they argue forever about causation. Well, it just didn't really cause it. How many angels on the pin, and can dance on the head of the pin, and well, what about this and what about that, and so forth. And causation is a big issue on summary judgment. Never seen it be a problem with a jury over 35 years of practice. Jury, if they believe they found who shot John, they're not going to have any problem with the causation element. They'll just wash right through that because they'll see the bigger picture of justice in it, not a little technical point on causation. Is this really just a match in a forest fire that didn't cause anything? All those arguments that are made on summary judgment are irrelevant at trial because they understand when A led to B in the practical sense that we all do, not in the philosophical sense of can we ever in fact know anything. That's great for philosophy course, but it's not great for a jury. What a jury wants to know is, what's going on here? What really happened? Here's another big mistake that I see lawyers make with juries. They say, he hasn't proved his case, or he hasn't proved this to you, or she hasn't proved that to you. Why does a lawyer argue the burden of proof? Why do they say, well, she hasn't proved her case, or he hasn't proved his case? They heard about burden of proof in law school. And there's no question that's an important part of the law. And they've got a jury instruction there that says the burden of proof is on the plaintiff or on the defendant for this point or that point. It's nonsense. The jury doesn't want to know whether somebody failed to prove something. They want to sort out the problem. They want to solve the mystery. They don't want to say, well, let's vote for the defense because we don't know. So when I try a case for a defendant, I've been accused of trying a defense case like I were the plaintiff. That is to say, I want the jury to be able to scratch what itches. I want the jury at the end of the day to be able to say, we sorted this out. We know what happened. We know where the truth lies. We know where the equities lie. I don't want them to say, I don't know what to do here. That's completely unpredictable. That is absolutely, completely unpredictable. So sure, there's burden of proof in there, but it's a big mistake with a jury to say, rule this way because we don't really know. They're there to find out. They're there to solve a mystery. They're there to give an answer, and they want to do that. And you as a lawyer have to show them how they do that and why they come to that answer. And you have to show them not just by citing the law. And I see a lot of lawyers leave that out. You get into your closing argument, I don't see the jury instructions up there as much as they should be. The jury understands that they've got to comply with those jury instructions. And so it's a powerful argument to say, you see there, the judge has instructed you or will instruct you that X, Y, and Z. In this case, what that means is, and you apply it to the law, so you equip the jurors to go back into the jury room and talk to one another and say, but remember, we got to apply it to the law here. So you've got to connect the law to your case. And then you've got to give them some practical illustrations or examples. You've got to give them some analogies. What is this like? What is this similar to that they know in their experience? It can be from books they've read. It can be from movies they've seen. That's very important nowadays because they've all seen movies. It can be from fairy tales. It can be from things that they've learned as children. So when you convince them that this is a case like such and such in a movie, or this is a situation like that in a book, then you give them an antecedent that they can hook it to, and they can not only see how it worked here, but they can see that that's a common thing that happens to people. That's a this is another example of something. For example, somebody lied over here about something small. And the question is, who lied over here about this oral contract? Well, the person who'll do it over here about something small is going to do it over here about something larger too. You know that from your common experience. How the twig is bent, the tree will grow. You've got to give them those kind of analogies and examples in order to tip that scale a little bit when they're looking for which way do we really go here.